Hello, and welcome to Santa Cruz County Traffic Court. Today, we are here for the Traffic Arraignment Calendar. My name is Gregory James Panato, and either myself or another judicial officer will hear the arraignment calendar today. If you need an assisted listening device, please advise the bailiff at this time. Please also advise the bailiff if you would like the assistance of an interpreter. Before calling the calendar and having each of you approach individually, I will advise you of your legal and constitutional rights, the pleas that may be entered, and the penalties for offenses in this court. I will provide you with information about traffic school, explain your plea options, and discuss matters for which proof of correction may be shown for reduced fines and fees. The court will not take a plea if you want traffic school, and this will be explained in more detail momentarily. Generally speaking, most matters on today's calendars are infractions, but you may also be here on a misdemeanor charge. If you are here on a misdemeanor charge, the court will specifically advise you of all your rights and consequences of any plea that is entered today. As it pertains to infractions, you have the following constitutional rights. You have the right to a speedy and public trial within 45 days of the arraignment date or plea of not guilty. Because the cases on this calendar are infractions, you do not have the right to a jury trial. If you choose to exercise your right to a trial, it would be a court trial in front of a commissioner or other judicial officer. This means that if you choose to plead not guilty, the court will ask you if you wish to have your matter heard within 45 days or waive time and have it heard after. Again, this is because you are constitutionally entitled to having your matter heard within 45 days. However, you do not have to have your matter heard within 45 days and can set it later for your convenience and the court convenience, and this is called waiving time. You do not waive any other rights by waiving time and having your matter heard later, and you will have more choices for your trial date if you do waive time. At a trial, you have the right to confront and cross-examine the witnesses against you. This is usually the peace officer who signed and issued you the citation. This means you can question the law enforcement officer involved in your case. You also have the right to present evidence on your own behalf and the right to use the court's subpoena power to compel witnesses to come to court to testify on your behalf or to call any other witnesses you believe relevant. You may also compel documents and request other evidence from the police agency. The law library at the Santa Cruz Courthouse or the self-help center at the Watsonville Courthouse may be able to assist you with these requests. You also have the right to hire your own private lawyer at your own expense, but you are not entitled to have an attorney appointed to you, since these offenses are infractions. You can also choose to represent yourself in traffic court, as most people do. You have the right against self-incrimination, which is known as the right to remain silent. This means that no one can compel you to testify or make any incriminating statements. This is because the officer is the witness for the people of the state of California and has the burden of proof beyond a reasonable doubt whether or not you choose to testify. You could choose to plead not guilty, set your case for trial, and still remain silent. However, you may give up this right and testify on your own behalf. If you do testify, you may also then be asked to answer some questions the court may have, which are usually clarifying questions. You also have the right to appeal the decision of the commissioner or judicial officer hearing your case after trial. You also have the right to an interpreter at all hearings if you would like. Those are your constitutional rights. Now, I will explain to you generally some penalties that can be imposed for infraction cases. For most offenses, there are fines. The judicial officer is required to impose most fines. There may also be additional fees on top of the fines, which may include additional state fees and other assessments. For every case where there is a fine or fee imposed, I will explain to you the fine or fee amount and then we can discuss payment options. In addition to fines, the court may suspend your driving privilege if you are convicted for certain offenses, such as driving over 100 miles per hour. The court may also order alcohol-related cases if your charge was alcohol-related. Now, I will discuss the pleas you may enter today and charges that may be corrected. A not guilty plea means that you wish to have a court trial. If you plead not guilty, your case will be set for trial, and the court will notify the pertinent law enforcement officers, who are generally those that issued or signed the citation. This is so those officers may be present for trial. Remember, if you plead not guilty, you will be asked, do you wish to have your matter heard within 45 days, or do you wish to waive time and have it heard outside of 45 days? A guilty or no contest plea means that you wish to admit you committed the violation and you do not want to have a court trial. If you plead guilty or no contest, you will be giving up all of the constitutional rights previously explained because you are saying you do not want a trial. If this is the choice you make, the judicial officer will again, in court, go over all of your rights with you to ensure that you understand the rights you are giving up in order to plead guilty or no contest. The court will treat the no contest plea the same as a guilty plea. You may choose either plea, and they will be treated the same for sentencing purposes. If you plead guilty or no contest today, the court will likely proceed to sentencing today. And by sentencing, I mean advise you of the penalties that apply in your case, which usually consist of fines. The court will not proceed to sentencing today if you advise the court that you would like to have your sentencing delayed. Sentencing can be delayed for up to 5 days. Most people opt not to wait, as they would then have to return to court within the next 5 days to be advised of what the penalties and fines are. But again, it is your right to come back after 6 hours, but within 5 days to be sentenced. If you are ordered to pay a fine, it will be due by a date that we discuss. If you need more time than that, you can also ask for a payment plan. Monthly payment plans can be set up for your case, which can be set up to begin immediately or set out at some point in the future, depending on your financial circumstances. If you select a payment plan, you will not receive any reminders about when those payments are due each month unless you sign up to receive text notifications. You must remember to make those monthly payment plans on your own before the due date for which is set up today. You can also request that the fine be converted to community service. The court will calculate how many volunteer service hours are required based upon the amount of your fine. If you choose this option, you would need to enroll in the program by a specified date that we discuss, and then complete those hours by a subsequent date we will discuss. If you believe you have a financial hardship pertaining to the fines imposed in your case, advise the court if you desire, and we can explore further whether you qualify for a fine reduction on that basis. It is your responsibility to pay the fine on or before the date the court orders. Please note that if you do not pay your fines on time, the court may refer your case to collections. If you find that you are not able to pay the fines for any reason, please go to the clerk's window in Santa Cruz or Watsonville and request a modification or extension form. In that form, you can explain your circumstances and request an extension or modification. These requests are reviewed regularly, and alternative orders or extensions can be considered so that you do not miss due dates. However, you must seek a sentence modification or extension form from the court before the fine is due. Do not let the due date pass. Now, let's discuss traffic school. Depending upon what you are charged with, you may be eligible for traffic school. Remember, at arraignment, you can take advantage of traffic school without entering a plea. There may also be payment options available now that are not available after a finding of guilt after trial. Regarding traffic school, if you are charged with a moving violation and you plead guilty or no contest to that charge, or if you are found guilty after trial, the conviction will appear on your DMV record as a point. The point will stay on your record for some time and may result in your insurance being increased during the time for which it remains on your record. If you would like to keep the point off your record, you can request to attend traffic school today. I will advise you if you are traffic school eligible. If you would like to take advantage of traffic school, you will still need to pay the fine amount for the underlying violation, along with a traffic school enrollment fee, which fee I will advise you of. You must enroll in traffic school and pay the fines and fees in a particular order, because if you do not, you may inadvertently preclude yourself from traffic school eligibility. If you would like to discuss a fine reduction or payment plan as it relates to traffic school, please let the judicial officer hearing your case know, and we can explain to you whether that option is available or what option is most similar to what you are requesting. You can choose to attend any traffic school you would like, even an online course, as long as it is approved by the Department of Motor Vehicles. You can go to the Santa Cruz Court's website and find links to the DMV-approved traffic schools. You will also likely have to pay additional fees to the traffic school you choose, and there may be a sliding scale that the traffic school you choose offers. After you complete traffic school, your conviction will not appear on your DMV record. Again, at arraignment, when I call the calendar and ask for people who would like traffic school, I will not ask you for a plea. You need only advise me that you would like to attend traffic school on the traffic school eligible offense. At that time, we will also discuss fines, fees, payment, and enrollment due dates. If you have attended traffic school for a violation that occurred within a certain time frame of your current violation, you may not be eligible for traffic school. You also cannot attend traffic school for certain offenses, such as equipment violations and some non-moving violations, since those violations generally do not result in points on your record and are not generally considered moving violations. If you request traffic school and it is ordered, but you failed to attend or failed to provide proof of attendance within the time frame required, the conviction will appear on your record and your traffic school fee will be forfeited. Let's now talk about correctable offenses. You may have been cited for what are commonly referred to as correctable offenses. If your charges include any correctable violations and you have proof of correction, please bring it with you when I call your case. I may be able to dismiss those charges with a transaction fee or fee much lower than the original fine. There are other charges similar to correctable offenses, but for which a fine reduction can be granted upon demonstration of proof of correction accompanied with a guilty or no contest plea. Again, these are not technically correctable offenses, but with proof of correction, the court can reduce the fines with a guilty or no contest plea. Regarding insurance requirements or violations of Vehicle Code 16028, failing to show proof of financial responsibility to a law enforcement officer at the time of the incident, that charge carries a significant fine, as noted on the courtesy notice you may have received. This is technically a correctable violation, and the court can dismiss the fine if you show an insurance document which has the policy period with effective and ending dates covering the date you were cited, lists the vehicle you were driving, and lists you as the insured person. However, if you were driving another person's vehicle and they had insurance, you would need to show that you were covered under their insurance, either through a letter from the insurance provider stating that you were, or it is reflected on the policy of the policyholder. If you cannot show this proof of coverage during the incident, you may enter a guilty or no contest plea and present proof of after acquired insurance, listing you as the named insured, and I may be able to reduce the fines significantly. If you were involved in a traffic accident, this violation is not correctable. With respect to trial, if you elect to plead not guilty and set your case for trial, while the court understands that you are not an attorney, the court does expect that you come to trial prepared to present evidence on your own behalf if you so choose, and understand the code section you are charged with violating. When I refer to evidence, that could only be your testimony. It does not have to be photographs or documents. But if you have those things, bring all of your evidence with you on the date of your trial. The date of the trial is the time for you to present any evidence if you so desire, but again, are not required to. If you should be found guilty and you would still like to be considered for traffic school, you must mention that you would like to attend traffic school before you leave the courtroom the day of trial. Otherwise, the court will consider it an untimely request. After trial, even if you request traffic school, it is in the court's discretion whether to permit traffic school. Whereas, if you request traffic school today at arraignment, the request will be granted without question if you are eligible. When I call your case, please step forward. At that time, we will discuss whether you would like to take advantage of traffic school if eligible, or would like to show proof of correction for correctable offenses, or would like to plead guilty or no contest, or would like to plead not guilty and request a trial. For those who want to plead not guilty and go to trial, again, I will ask those people whether they want to waive their right to have a trial within 45 days or have their speedy trial within 45 days. If you do wish to plead guilty or no contest, let the court know and we can discuss the fines and fees for the case. I will also allow you to explain any mitigating factors that might justify a fine reduction, if you wish. Again, please advise the bailiff if you need any assisted listening devices or would like an interpreter. Finally, if you have any questions regarding any of the information from this video or otherwise, please do not hesitate to ask for clarification or further explanation when your case is called. Thanks.